for storage of wills to be maintained at the courts. Second, the bill would allow court staff and as the Register of Wills to issue letters of appointment for personal representatives rather than first requiring judicial review. Third, the bill would shorten and condense the notice of probate publication from 2 publications over a duration of 3 weeks to 1 publication over a duration of 2 weeks. Fourth, the bill would increase the amounts for reimbursable funeral expenses from $1,500 to $10,000 and the maximum threshold for what qualifies as a small estate from $40,000 to $80,000 to be consistent with inflation. Fifth, the bill would allow for transfers of small estate property through affidavits in lieu of judicial decision. Sixth, the bill increases homestead and family allowances from $15,000 to $30,000 and exempts property allowances from $10,000 up to $20,000. Lastly, the bill would update related legal terminology in the DC Code. Our committee print retains most of the introduced bill, but makes 2 substantive changes. First, after long and careful deliberation, we decided to remove the electronic will registry provision to be pursued at a later time. Due to concerns over lack of physical storage space and a lot of understaffing at the courts, the introduced version of the bill had proposed a novel electronic will registry. While innovative, electronic storage of original wills has raised various legal questions and challenges. In consultation with advocates and court staff, the committee also considered the possibility of a physical will registry to be housed at the courts or another agency. However, the establishment of a physical will registry raised significant spatial, practical, and financial concerns for the courts. Because we are not a state yet, the district courts are federally administered and congressionally funded rather than supported by local district dollars. And so when the council legislates requirements on the courts, we cannot attach funding from local district dollars to implement those changes. And as a result, additional requirements have the potential to strain our limited court resources and staffing. I want to be very clear, though, I wholeheartedly agree with advocates, with public witnesses and the working group and the introduced version, Councilmember Allen, that a will registry would and will provide a meaningful service to district residents and is sorely needed. It is concerning that the district remains an outlier in not providing this will registry. And so I want to emphasize that while we're deferring this piece of the proposal for now, I believe in this proposal and think it should be robustly revisited in the future with the accompanying appropriate supports to ensure that our courts can implement it with fidelity. Second, we have added an absolute fee waiver for personal representatives to make sure that the law that the council passed in 2022, the Expanding Fee Access for Low-Income Litigants Amendment Act, is not being partially or inconsistently applied in the probate division. This law, effective since February 2023, allows eligible indigent litigants to observe absolute fee waivers for filings rather than so-called prepayment fee waivers, which are waivers that have to be paid back eventually. Our print ensures that these absolute fee waivers also apply to indigent personal representatives in probate. The other changes we make in the print include raising the allowable funeral expenses to $15,000, up from the proposed $10,000 in the introduced version, to be consistent with Maryland law, and extending the timeline for the homestead deduction and senior tax relief to 1 year after the owner's death. I'm hopeful that this bill, if enacted, will address and redress current challenges within our probate system in order to improve administration and ensure equitable access to our civil system. Lastly, I just want to thank the many residents that we have worked with over the last several years who have come to us with their personal experiences dealing with probate, and want you to know that those stories have been deeply impactful to me and my team as we navigated what these appropriate thresholds should be, how we should make the process easier in this moment of human need that people are going through and dealing with probate. I think it is incumbent on all of us as a system to make sure it is as easy and cost effective and supportive as possible. And so I want to thank all of those residents for their courage and bravery in having their stories be part of improvements for future residents in the future. With that, I now move the print and report, Bill 25-538, with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? Councilmember Allen.
Thank you very much, Madam Chair. First, let me express my gratitude and appreciation for you and your staff moving this bill forward today. This is a large committee with a lot of things in your jurisdiction, and so making sure that this bill moves is a priority It's important for the district, but I appreciate you making sure that this had time on the agenda to move forward before the council period ended. You mentioned at the top that I introduced this bill alongside yourself and 8 of our council colleagues, and we did so to address a problem that, frankly, so many of us don't like to talk about. And sometimes we don't even acknowledge what's going to happen to each and every one of us and everyone we know: death. We have a system in place currently that provides a process for how a loved one's assets are going to be transferred or divided amongst next of kin or other family members when they pass away. That process is called probate. And for those who have had the difficult experience of going through that process, it is arcane, it is complex, it is time consuming, and it's extremely difficult. On top of that, if you live in the district, it's more likely that you're going to be going through this process alone without the assistance of an attorney. 97% of small estate cases in DC Superior Court are pursued by pro se litigants. That is, they don't have an attorney by their side guiding them through that process. Probate may seem like an innocuous or inconsequential topic given the complexities of the process, but it can have profound implications for a family in building intergenerational wealth. Obviously, we can demonstrate with a very well-publicized example from 15 years ago. When Hurricane Katrina ravaged New Orleans, thousands of people could not receive even disaster relief from state and federal authorities because they did not hold clear title to the homes that they occupied. Here in the district, we see it happen all too often to intergenerational homes when a family matriarch or member passes away with no clear title and lost over the generations. And we know who stands to lose from a process that is complex and time consuming. It's lower income residents, primarily Black and Brown residents of the District of Columbia. I'll underscore that currently the ability to navigate the probate process is the difference between keeping that multi-generational home here in the district or losing the home, the generational wealth that it may promise, and the family members being forced to relocate elsewhere. That ability hinges on the financial resources one has, the ability to secure pro bono representation, or the wherewithal to navigate this cumbersome process. None of these are a given when the stakes are high, and I think we can all agree it shouldn't be this way. Back in February of 2022, the Council for Court Excellence and the DC Access to Justice Commission published the Strengthening Probate Administration in the District of Columbia report, which was the catalyst and basis of the bill before us today. The report discussed how much of our probate system has not been updated since 2001. That was over 23 years ago, and a lot has changed. Things are more expensive and expectations have changed, and I won't go into what the bill does since you've already laid all of that out, Madam Chair, but I do want to emphasize and underscore the changes being proposed through this bill will make our probate administration a much easier process to manage and navigate for folks who we know have the most to lose. I also just make a brief moment and emphasize your comments about the will registry. As you noted, it was a provision that was removed from the bill after the committee engaged substantively from the court. The court expressed concerns to the provision, some of which I can empathize with and understand why it was the basis for the provision being removed today. But I did want to take a second and stress how important this provision is, and also my intention to continue to work with you and others moving this idea forward in a different mechanism. Currently, storing a will is the responsibility of the testator, i.e., the person for whom the will is for or their attorney. And just with any other important legal document that we store at home, it can be misplaced, it can be destroyed, anyone can be affected. Just ask Aretha Franklin's family, who found 2 crumpled notes under the couch after she passed away. Before I conclude, I want to express my gratitude to the Council for Court Excellence, the DC Access to Justice Commission, all members of the DC Estate Administration Working Group, Legal Counsel for the Elderly, DC Affordable Law Firm, and all the public witnesses who testified at the hearing back in June. Again, I really want to thank you for your work here, being able to borrow off and learn from the expertise and advocacy of our neighbors across the district. They were crucial to getting this bill before us today, and I really appreciate your hard work. Thank you, Madam Chair.
Thank you very much, Councilmember Allen. Is there any other discussion? All right. With that, I now move the print and report for Bill 25-538 with leave for staff to make technical, editorial, and conforming changes. We'll do this by a voice vote. All those in favor, please signify by saying aye.
Aye.
The ayes have it unanimously. We will now move to Bill 25-955, Child Marriage Prohibition Amendment Act of 2024. I introduced this legislation along with Council Members Nadeau, Lewis George, Henderson, Robert White, Bonds, Fruman, Gray, and Parker on September 16th of this year. The legislation was also co-sponsored by Council Members Trayon White and Charles Allen. The Child Marriage Prohibition Amendment Act of 2024 protects young people by setting the legal age for marriage at 18 and prohibits the clerk of DC Superior Court from issuing a marriage license to anyone under the age of 18 with no exceptions. Child marriage is a real and persistent problem in the United States and a growing concern in the District of Columbia. Between 2012 and 2022, 41 minors were married in the district. with an uptick of minors getting married here from one child in 2022 to 15 in 2023. This uptick was likely a response to greater restrictions we've seen on child marriage in our neighboring jurisdictions. 80% of those marriages involved young girls wed to adult men. The harm caused by allowing individuals under 18 is clear. Many studies show that child marriage is associated with an increased likelihood of domestic abuse and economic instability and significantly lower educational attainment, outcomes that impact individuals for the rest of their lives. Even the US State Department calls marriage before the age of 18 a human rights abuse. Current law in Washington, D.C. allows 16 and 17-year-olds to marry another person of any age with the consent of just one parent. With that consent in hand, anyone, regardless of where they live, can walk into a clerk's office in the District of Columbia and marry a child. During this process, the child is not questioned about whether or not they consent to the marriage. By allowing children to be married with nothing more than one parent's consent, no oversight to ensure that the marriage is not predatory or that the minor wants to be married, and no requirement that the individuals being married are district residents, the district has inadvertently positioned itself as a possible destination for child marriages. Setting the age at 18 with no exceptions is important because at 18, a person then has the legal capacity to make informed, independent decisions about their lives. And I believe that we owe it to our young people to protect them before the age of consent. With that, I move the bill and report of Bill 25-955 with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? Okay. Will all those in favor please signify by saying aye?
Aye.
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 The ayes have it, and it is unanimous. Third and last, we will turn to Bill 25-914, the Safe and Supported Pregnancy Amendment Act of 2024. This legislation was introduced by Councilmember Henderson, as well as Gray, Robert White, Tran White, Parker, Allen, and myself. Pregnancy should be a time filled with care, compassion, and emotional as well as physical support. It should be a time where a birthing person can receive all the pre and postpartum resources that they need to have a healthy delivery that will support the health of both the mother and the baby. When a person is pregnant, they need a proper diet, prenatal vitamins, regular medical checkups, exercise, emotional support, a birth plan, and continued support to nurture a new life. Unfortunately, the experience of incarcerated individuals often reflects the opposite of this. The healthcare that incarcerated people receive while pregnant is often inadequate, which can put them at risk for higher rates of complications, such as miscarriages, preterm deliveries, and low birth weight infants. This legislation was inspired by the experiences of two individuals who recently gave birth while in the custody of the Department of Corrections, or DOC. The Safe and Supported Pregnancy Amendment Act of 2024 seeks to address this by ensuring that DOC is providing additional resources and supports for incarcerated individuals who are pregnant while in their custody. For example, the legislation makes pregnancy testing and pregnancy counseling options available to women who are pregnant or may be pregnant. Offering specific pregnancy-related counseling helps individuals make informed decisions about their health and next steps, fostering a sense of agency and reducing stress. This is an important step to ensure that our incarcerated individuals who are pregnant receive confidential, timely, culturally responsive, and comprehensive care. The bill also provides a pregnant individual with a method to request the presence of a support or alternate support person during delivery and to connect them with family law attorney to help make decisions regarding the child's custody and placement. Allowing a trusted person into the delivery room with the incarcerated person during birth can improve maternal and infant health outcomes by reducing stress and enhancing advocacy for care, while also promoting human dignity and reducing psychological trauma, and ensuring that pregnant individual has access to the legal resources they will need to support more positive long-term outcomes for the parent and for the child. The bill additionally requires that DOC provides necessary supplies for safe storage and transportation of breast milk, something we know is crucial to support the health and well-being of both the mother and the child. After the baby is born, those first hours and days are critical for establishing that parent-infant bond, which has important benefits for psychological development and for the mental health well-being of the postpartum person. It is also essential to establish milk supply for those who choose to breastfeed their infant during this time. Providing these resources aligns with public health best practices, promotes family bonding, and demonstrates humane treatment that everybody deserves. Lastly, the bill provides for a private right of action so that an individual who believes that any of these rights have been violated may file for damages or other remedies as are appropriate. For example, the two women who submitted written testimony who were incarcerated reported being placed in restraints during their pregnancy, guards attempting to restrain them in the hospital after delivering their child, and when being transported back to DOC from the hospital. This type of restraint violates the current law and policy. And so we need to make sure that there are teeth and enforcement mechanisms in place so that if one of those policies that we're setting out today are violated, there is an avenue to seek redress. With this new provision, anyone who experiences a violation of their rights will go through the traditional grievance process first, and if they still do not receive recourse, they can file for a private cause of action with the courts. The bill also expands the reporting requirements on the use of restraints to require DOC to annually submit to the council secretary and the chairperson of this committee the information related to their use of restraints. That should only be left for extenuating circumstances in this type of situation. I am confident that the provisions of this bill will improve the resources and supports available to women who are incarcerated or people who are pregnant while in the custody of DOC and meaningfully improve outcomes for parents and their children. I really want to thank Councilmember Henderson for not only introducing this bill, but working so hard on all the provisions of this bill, bringing to life the experiences and helping the two women who have recently experienced this really be a part of this process and ensuring that going forward, women who give birth and people who give birth in custody have basic rights and protections and that their and their baby's health is respected. So thank you to you and your team. With that, I now move the print and report of Bill 25-914, with leave for staff to make technical, editorial, and conforming changes. Is there any discussion? Councilor Henderson.
Thank you so much, Chair Pinto, for moving this bill today. I introduced this bill out of extreme concern and disappointment after learning about the experiences of two pregnant women who are in the district's custody at the Department of Corrections. As chair of the Committee on Health, I regularly hear about the healthcare challenges faced by district residents, but I know that for those who are in custody, the barriers to quality care are even more severe. For people with freedom to choose their medical providers, accessing regular and quality care is already difficult, but for those who are in jail, the situation is more dire as their healthcare needs depend entirely on a system whose primary concern is not necessarily promoting health outcomes, but ensuring the institution's physical safety. I think it's possible and right to balance both the health and well-being of residents with security and that it is unacceptable that incarcerated individuals experience substandard care and neglect. The women whose testimony led to the creation of this bill shared troubling accounts of inadequate care, including unmet medical needs, poor nutrition, lack of access to breastfeeding equipment, and even being handcuffed late in their pregnancies and after delivering their babies, after notifying the guards of their rights under existing DC law. Their experiences are unacceptable and underscore the urgent need for the reforms proposed in this bill. I think this bill represents a significant step forward in ensuring rights and well-being of pregnant people in custody. Um, uh, you know, I'm not going to go over the bill again because you gave such a thorough description of all of the various pieces, but I do want to highlight that this bill does also create a private right of action for individuals whose rights under this law and the limitations on the Use of Restraints Act are violated. Testimony from incarcerated women revealed that DOC personnel already failed to comply with existing laws about restraints. And so I felt that a private right of action was necessary, and I'm glad that the committee agreed. I do want to briefly mention the fiscal impact statement that was provided for this legislation from the Office of the Chief Financial Officer. I've used comments in the past about FIS and disagreements with those, but I feel like this is another one. The Department of Corrections is saying that they're going to require 3 new FTEs to implement this bill. One FTE would be what they refer to as a pregnancy liaison, which I find deeply interesting given that no more than 6 people in a year have delivered a baby while in DOC custody over the past 10 years. So my question for the Department of Corrections is, what exactly is this person going to do with the rest of their time? It could be 1 baby, it could be 6, but that certainly isn't a full FTE. Further, they were said that 2 more correctional officers will be needed to meet the provisions of the bill requiring additional visitation for residents with children under 1 year old. As of September 30th, based on their own records, the Department of Corrections had 126 uniformed vacancies. But you need 2 more to introduce to fulfill this bill. I fail to understand how the department can claim with any real seriousness that they need to hire additional officers so that a resident can be in the visitation room more frequently. And so I've reached out to the Office of the Chief Financial Officer to communicate to the agency, and I hope to follow up with the agency so that we can resolve this, because frankly, this looks to me as though the administration is saying they don't like the bill, which is unfortunate given that I think this definitely moves it in the right direction for positive health outcomes, not only for those who have recently given birth, but also their families. I want to thank the attorneys at the Washington Lawyers Committee for Civil Rights Under the Law who first alerted me to the issues faced by their clients. And I want to also thank the DC Justice Lab for their support. And to London Teeter and Tanaya Vini for sharing their experiences, for being brave enough to share their experiences. And I also want to thank you, Chair Pinto, and your committee staff for moving this bill so quickly, acknowledging the urgency of addressing these issues. So thank you so much.
Any other discussion? Thank you very much, Councilor Henderson. And I do just want to note on the cost concerns and with DOC, I do believe that DOC has a staffing challenge across the agency. This has been true for many, many years, just like we've seen with all of our public safety agencies. And I'm committed to working with them to address that and try to work through filling those vacancies. That does not mean that accommodating a small group of people to ensure that they have basic health care requires more staff just to do that piece. And so I look forward to working with you in the coming days to make this fist right and accurately reflect what we believe is the truth about the cost of this bill as we simultaneously continue to work on the staffing issues at DOC, which is a much larger problem and challenge that I am committed to. So thank you very much for raising that. There being no further business for the committee today, the time is now, I'm sorry. Thank you so much. Ahead of myself, so excited. I would like to call this measure to a vote. All those in favor, please signify by saying aye.
Aye.
Aye. Thank you, and thank you for letting me know that. There being no further business before the committee today, the time is now 3:05 p.m. and we are adjourned.